Oh boy. He's in the that's the one adjourned. Good morning, Your Honor. Nathan Turner requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Portio here. Portio here. Feaster, I'm sorry. I
thought he was doing really well. I'm just vision of Torcio here.
For a second, that was his last name. I apologize.
Wow.
I apologize, Your Honor.
No, hey, you did what you could. Have you been before me before? Oh, he's got to have another meeting.
Not present. Representing Mr. Howard, who is unfortunately not present because he's in the hospital.
Have you been before me before?
No, sir.
No, I can tell. Where are you from?
Originally, I'm from Georgia, Your Honor.
Georgia?
Yes, sir.
Okay, well, that explains part of it.
I have.
So, where'd you go to undergrad?
Harvard, actually.
Like that means anything. All right.
I was going to say that explains
itself. Yeah, that does. All right. So you went from Georgia to Harvard.
I did.
Yeah, that had to be a shock. And then where'd you go to law school?
I'm currently in law school at Michigan, Your Honor.
So you upgraded. That's bad.
That's right.
Okay. What part of Georgia?
South Georgia.
South Georgia. That's a big area.
It's called Albany, Georgia. The native.
Albany. Yeah. So I kind of know where that is. The guy had crawled out from under a rock. So he's from Albany to Georgia to Harvard.
That's right.
And now to Michigan.
That's right.
And you said Torcio here. Okay, whatever. No, apparently your education's done you well. All right. Permission to practice is granted. Go ahead.
I apologize, Your Honor. I was just given this case to do the item.
Your Honor, may counsel approach.
Yes, you can.
Okay.
Feaster here. Come on up. Bring him. I don't know, Johnson. What's going on? What are we doing in this case?
Reach for resolution in this matter, Your Honor. The defendant is going to be pleading no contest to count 2 and it's added to count 3 of attempt R&O. In exchange, count 1 will be dismissed.
And in looking at this, that's the court's full understanding. Has he signed a sentencing judge waiver?
He has, Your Honor, and we're signing the advice of rights right now.
All right. No, Johnson, this way.
Oh, yes.
No, this way. You know the rules.
Yes, sir.
Let's have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Up you go. State your name.
James Johnson.
All right. So Johnson, it's this court's understanding that you're going to be pleading no contest to 2 charges. Is that your understanding? Yep. First charge is to charge the stated count 2 of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
Second charge is the offense of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and or $1,000 fine plus court costs. You understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
Court will accept the defendant's no contest pleas to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this case will be
August 21st at 10 a.m. before Judge Perry.
August 21st, 2024, 10 a.m. before Judge Perry. Bond in this case will continue. Oh,
I
yes, that's the bond.
am the first person to admit that I am wrong. I was wrong with regard to the phone privileges. What Mr. Johnson represented to the court at the last hearing, that despite the fact that he was calling the victim's phone number, he was contacting a second woman in the relationship,
I remember.
Alicia, is accurate based off of listening to more of the phone calls. So at this time, I have no objection to defense's request to reinstate the defendant's phone privileges.
Anything else on that, Mr. Burns?
I have nothing to add, Your Honor, but I appreciate Ms. Barroso saying that we're asking that the phone privileges be reinstated. And I do have a couple of other bond requests of the court, if I could.
Yes.
So James right now has an August 7th court date before Judge Conlon for probation violation. The recommendation there is released to treatment. I'm wondering.
That's out of from this case?
Yes, Your Honor, this is the case that led to the violation. The recommendation from probation right now is released to treatment. I'm asking that the court would please consider amending the bond here to allow for release to treatment when that becomes available, if that is in fact ordered by Judge Conlon.
Any response to that request from the people?
No, Your Honor.
Anything else, Mr. Clerk?
I have one more, Your Honor. Maybe on the stickier side of my bond request, but Ms. VC is the named victim in the case here. There's obviously no contact order with her. She's quite pregnant at the moment. Mr. Johnson is asking if
I heard last time.
please, fair enough. Asking if the court would please
But
consider.
so's the other one.
Yeah, they both are. Indeed.
Yeah, man, I know. It's complicated.
Not really. It works. Anyway, go ahead. Never mind.
Never a dull moment, Judge. If there's any type of no non-consensual contact provision in whatever form to allow communication with Ms. VC would be very much appreciated.
Yeah. Is there a response to that from the people?
Your Honor, the victim is present and would like to address the court on that matter.
All right. I need to have Mr. James. Hello, what's your name?
Kamaya VC.
All right. What did you want to tell the court?
I just want to tell the court I'm asking for it to be lifted too. I've been going through it without being able to contact him, him being able to contact me. And, I just been through a lot of stress and everything. I'm just asking it to be lifted.
All right. So you want me to order no non-consensual contact, meaning that as long as you're okay with it, he could contact you?
Yes.
All right. Okay.
Thank you. I appreciate it.
Hey, get up there. Listen to people. You can just focus for a minute. All right. Anything else?
That's all I got, Your Honor. Thank you.
All right. I will order that the defendant, first of all, the defendant phone privileges are hereby reinstated. The defendant may be released on a PR with the conditions remaining to inpatient treatment. And I would amend the no contact provision to no non-consensual contact with the victim in this case. All right.
Your Honor.
All right. I had a whole lot of questions for her, but I'll let it pass. No, go. Just go. Just go. We'll see you next time. Yes, you told me that the last time. Oh, boy.
Your Honor,
Oh, boy. He's back.
Nathan Turner requesting permission to practice pursuant to Michigan Court Rule.
Seriously?
8.120.
Seriously?
Under
Seriously?
supervision.
Seriously, hold on just a minute. Carrie, did you talk to him at all?
I did, Judge.
All right. Did you tell him that I only need that once per session?
I did not.
You did not.
I did not.
Why didn't you tell him that?
I apologize, Your Honor.
Because now he's standing up here still rambling through that stuff. You got kind of that Georgia Harvard thing going on.
That's right.
I can only understand every third word. And you made him say all that again.
Kind of like a.
Well, when he got to the end of it, this is really what I want to know. When he got to the end and he said, under the supervision, who was he going to say? He would be you this time?
It would be me. This
Okay,
time.
not Feaster here.
That's correct.
Okay, all right.
That's why he wanted to say it.
That's why he wanted to do it? Oh, well, fine, go ahead. I'm listening. No, go ahead. No, the whole thing, again.
Oh, good morning, Your Honor. Nathan Turner requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Shanaza Karyakan-Rowley, representing Mr. Emil Thomas, who is here with me today.
All right, permission to practice is granted again.
Thank you.
All right, what are we doing on this case?
Was provided some information by the public defender about obtaining a CPL. He had one previously. It was expired at the time of this incident, but he's since received a CPL. Based on that, in the interest of justice, I'm going to have a nollie cross filed with this court probably by the end of today, if that's okay.
All right. Any objection to that?
No objection at all, Your Honor.
You think you won some? you see that? He smiled. Oh, I don't have any objection. All right. This case is nollie cross. It'll be dismissed, sir. Thank you.
Thank you.
Thank you, Your Honor.
Your Honor, they call it dropping the H-bomb. And so they should expect this type of reaction when they do drop the H-bomb. Some people say they went to college, Cambridge, and just leave it at that.
Leave it at that.
I dropped it very reluctantly.
No.
In that situation.
No, you were trying to brag. I get it.
I was like,
I get it, but you don't understand. That means nothing to us.
I know, that's why I was reluctant.
Nothing at all. I don't even know where that is. Some school, someplace. Court has called.
What begins as a routine court session quickly turns into a unique mix of humor, authority, and serious legal consequences, a reminder that even in tense environments, the courtroom can shift tone in an instant. The hearing opens with a young law student stepping forward, nervously requesting permission to practice under supervision. His name, Nathan Turner. From the very first moment, something feels different. The judge notices it too. What starts as a simple procedural request quickly turns into an unexpected exchange. The judge questions him about his background, where he's from, where he studied, and the answers spark a light but memorable moment. From Georgia to Harvard to Michigan Law School. An impressive journey, but in this courtroom, credentials don't carry weight the way one might expect. The judge jokes, teases, and challenges him, making it clear that while education is notable, it doesn't define credibility inside the courtroom. Permission is granted, and just like that, the tone shifts, the case moves forward, a defendant, Mr. Johnson, stands before the court preparing to enter a no-contest plea. The charges are serious but controlled. Domestic violence and attempted resisting and obstructing a police officer. The judge carefully walks through each charge, ensuring the defendant understands the consequences. Maximum jail time. Fines. Legal implications. Everything is laid out clearly. The plea is accepted. 1. Charge is dismissed, and sentencing is scheduled. At this point, the case seems straightforward, almost resolved, but then, a surprising turn. The prosecution does something rarely seen. They admit they were wrong previously. They had objected to restoring the defendant's phone privileges, believing he was contacting the victim improperly. But after reviewing the evidence more closely, they acknowledged that their assumption was incorrect. It's a rare moment of honesty and correction inside the courtroom. And it changes everything. The defense quickly builds on that momentum. They request not just the restoration of phone privileges, but also adjustments to bond conditions, including the possibility of release for inpatient treatment. Then comes the most sensitive issue of all. The no-contact order. The alleged victim is present in court, and what she says shifts the emotional weight of the case entirely. She asks the judge to lift the restriction. She explains the stress, the emotional toll, and her desire to have communication restored on her own terms. It's complicated. Personal. And deeply human. The judge listens carefully. Then crafts a balanced decision. Contact will be allowed, but only if it is mutually agreed upon. A non-consensual contact restriction replaces the original no contact order. It's a nuanced ruling, reflecting the complexity of real-life relationships that don't always fit neatly into legal categories. The defendant is granted personal recognizance release, with conditions including treatment. For a moment, it seems like resolution has been reached, but the courtroom isn't done yet. The young law student returns for another case and repeats his full formal introduction again. That's when the judge stops him. Firmly. Almost comically, the courtroom breaks into a moment of light tension as the judge explains that such formalities only need to be stated once, not repeated. Every time. It's a subtle lesson. Know the rules of the room. Finally, the last case is called A New Defendant. Different situation. The prosecution announces a decision. The case will be dismissed. No objections. No resistance. Just like that, it's over. And yet the judge leaves one final impression, a commentary on perception, humility, and how people present themselves. A reminder that in the courtroom, actions speak louder than credentials, because in the end, this session wasn't just about legal outcomes. It was about people. Their behavior, their honesty. Their growth, and the understanding that in a courtroom, whether you're a seasoned attorney, a nervous law student, or a defendant facing serious charges, respect, awareness, and accountability will always matter more than where you came from.